Okay, good morning to everybody. Welcome to this webinar. Someone just confirmed to me that you can hear me properly.
Yes, we can.
Sharon, we can hear you.
Thank you. Yeah, a very warm welcome from the Kenya Copyright Board to the webinar. My name is Sharon Wata. I'm the Assistant Director for Legal and Technical Affairs at Kenya Copyright Board. We are happy to have you. We are looking forward to really having good discussions on this issue of movable property as security registry, which will be based on the Movable Property Security Act of 2017. I have two very knowledgeable, very exciting presenters in line for you, but I'll be your moderator for the day. Our IT people are trying to help us with the chat icon, and so because from my end I cannot see it, I don't know if you're able to see it from your end. But if you're able to access the chat icon, feel free to send your questions there as the meeting goes on. But we will have a question and answer time a bit later. 1 minute. We'll have a question and answer time a bit later. But as the meeting goes on and your questions come up, we would appreciate if you would write them down on the chat icon, yeah? Write them down on the chat icon. We'll be able to see your questions, but we will also take questions after the presenters are done. And so as I told you, I work at KECOBO, Kenya Copyright Board. Kenya Copyright Board is a state corporation. Under the Copyright Act, we are mandated to administer, to enforce copyright in Kenya. Part of our functions include licensing and supervision of collective management organizations. We have a training function where we do public education, we train stakeholders, and in general, do trainings. We do prosecution of copyright cases, but now the prosecution is really vested within the DPP, but we still conduct the investigations and the arrests. We advise the government on matters copyright, we manage the legislation, and we also do registration of copyright. I'm sure when one of our presenters comes through, you will get to learn a bit about registration in regards to the Movable Property Security Act, and it's something similar that we do. We have recently unveiled a national rights registry where our creatives, copyright holders and owners are able to go to the website and register their copyright with us. So without taking much of your time, I will introduce our speakers today, our presenters. Today I have two presenters for you. I've tried to do gender balance. So since there are two, we have a lady, Ms. Shigadi Mwakio. She's the Deputy Registrar at the Business Registration Services. She's also an advocate of the High Court of Kenya. She has over 5 years experience in commercial law, legislative drafting. She has been instrumental in various legislative forms under the Business Registration Services that led to the improvement of Kenyans standing in the World Bank, doing business ranking in protecting minority investors indicator, getting credit indicator, and resolving insolvency indicator. She was involved in the development of the Movable Property Security Rights Regulations 2017. These are the regulations to the act that we will be discussing today. The company's Beneficial Ownership Information Regulations 2020 and the Draft Partnership, Limited Partnerships Regulations 2020. She has been instrumental in the secure transaction legislative reform process in Kenya from 2017. She's also a member of the Task Force on National Risk Assessment on Money Laundering and Terrorism Financing, and she also sits in the Ease of Doing Business Transformation Team that has been responsible for the improvement of Kenya's standing in the World Bank Doing Business ranking. Now, Mwakio, you are very welcome. We are glad that you accepted to come and help us do this. I think I'll let you start us off first, and then I will do the introduction of Daktari when he's coming on. So please have the floor. If you have something to share, I think you can be able to share your screen. If not, you can just go on. Karibu sana.
Thank you so much, Sharon. Let me know if you can see my screen.
Yes.
Okay, so I'll briefly talk about what the business registration service does, and then take you through the statistics. And then now I allow Dr. Jeramba to come in and give you the juicy part of this webinar. So in terms of the legislative reform, so business registration service is used to be the former registrar of general's it used to be under the registrar of general's office, whereby we had the company's registry, we had the official receiver, we had so many other departments under it. And so business registration service moved from it. The Registrar General's office still exists, and it comprises of the marriages, societies, and others, while the Business Registration Service Act, the business service deals with the company's registry, it deals with the official receiver, it deals with the former chartels, so the collateral registry, and then we also have the hire purchase. We do find that prior to 2015, where a number of reforms started taking place, we had the Companies Act Cap 486, we had the Bankruptcy Act, we had the Chattels Transfer, Pawnbrokers Act, and the Hire Purchase Act. So prior to coming into force of the service, we find that we felt the need of trying to align most of our acts with the current trends. So we amended 3 of the acts here, 4 actually. So we amended the companies, we repealed it to have the Companies Act 2015. We repealed the Bankruptcy Act to have the Insolvency Act. And then the Chattels Transfer and the Pawnbrokers Act were repealed to have the movable property security rights. The Hire Purchase Act still exists, and it was just amended, and we no longer require people to submit their agreements. All we need is for you to register it at the initial notice under the MPSR registry, and we license the hire purchase registries. And in terms of the process reforms, like I have indicated, we house the company's registry. I'll first start with that. We do find that we used to have the manual processes, and they were and we do find that it was cumbersome, and a number of things used to happen there. And so with the new regime, we do find that almost everything went to the manual platform. So currently we have 80% of our services have been automated. CR12 right now, you don't have to come to Sharia House, you don't have to pay a broker to do it for you. You do find that you pay immediately as long as the company has been verified from our end, then you get the CR12 immediately. And then before we had so many of the manual applications. If you go to the eCitizen platform currently, you do find that under the business registration service, we have the manual application drop down. So every application that used to happen manually, now you can submit the same via the eCitizen platform. We also, the annual return was something that was a bit tiring for those people who normally do this, and we made it quite simpler. Now you don't have to fill most of the information. It's auto-generated. All you need to do is sign and upload. And then there's also the beneficial ownership information that we require you to submit for the existing companies, and for the new companies, it's automatic. You just need to fill that information. The deadline passed. So for those who have not complied, kindly ensure that you comply. And then I've talked about linker business. This is a process whereby we are trying to ensure that the records that we have at the company's registry match with what you believe to be the true position of the company. And so you give us that information about your business, and then from our end, we verify from what you have. If it matches, the company is linked. And the beauty about linking your business is that all the information now you need from the company registry will be auto-generated. If it's a CR12, it's immediately you pay, you get your output. And then we have also integrated with various national databases. You know of the IPRS, whereby we query the system. All we need you to do to give us is your ID number and the first name, and we're able to auto-populate your information. We also have integrated with KRA, NSSF, and NHIA. For those who have made an application, a new application of a business, of a company, you know that you no longer need to visit KRA, NSSF, NHIA. All this information, once you have submitted the application for registration of a company, all the other information is sent immediately to the email addresses that you have provided. And then I've indicated that we also have the official receiver, and the official receiver, as I have indicated, repealed their act, and with it came in good things. We do find there is an introduction of different alternatives to bankruptcy, which focuses on debt restructuring mechanism. They include voluntary arrangements, summary installment, no asset procedure. And for companies, the Act provides for alternatives to liquidation. We have company voluntary arrangement, administration, and administrative receiverships. So Dr. Jeramba will dive deep into now our other registry, which deals with both the hire purchase and the collateral registry. But the benefit of this registry so far is we do find that there is an increase in the access to credit, and Dr. Jeramba should be able to talk more about the benefits of this registry. So from my end, I'd like to share the statistics that we have on our registry. Currently, this is the information that we have from 2017 to 2021 of the type of assets that have been, the movable properties that have been used to secure credit. So we do find that so many people are using household goods to secure credit. Then motor vehicle is ranked second. You can see that we do have intellectual property, whereby we have received 1,000. I'm lost. Can you hear
Sorry,
me?
you can. I think someone had it muted.
Oh, okay. So you can see that the intellectual property we have received currently 1,115 initial notices to that effect. So people are using IP intellectual property to secure credit. And then in terms of so the purpose, you'll find that we wanted to ensure that we are all inclusive. And prior to this act, you'd find that the micro, medium, and small enterprises really had a challenge to access credit. But from the statistics now, you can see the uptake of the micro, small, medium, and women-led enterprises is has quite improved. They are actually the ones who are using the system more, the movable assets more, to access credit. And then the citizens, you know that when you used to go to a bank, it used to be difficult. If you don't have a car, if you don't have if you don't have land, then it's quite challenging. But the statistics are currently showing that so many individuals are able to access credit using the movable assets. And then in terms of who is issuing more, you find that even individuals are now using this system to loan each other using the movable assets. So you find that the others are quite well versed, or have the uptake of other people in feeling secure to use this registry, to use the movable assets to issue or obtain credit has quite improved. And these are the statistics from it. Banks are also ranked the second. We have the SACCO, we have the credit firms. So I'll let Sharon introduce Dr. Jeramba. That's more all about the business registration service. I'll take you later on through the MPSR registry. Thank you.
Thank you very much, Shigadi, for the informative introduction. I think one of the questions we've always had, people have always been asking and wondering, are we able to use intellectual property as collateral for loans? And that, of course, includes copyright. And sometimes it's a very difficult question for us to answer. We have found that a bit of a challenge. We have always wanted to have the data. At least you have shared with us some data on uptake of collaterals from IP. Yeah. I think the other question that has been very recurring for us has been the mechanisms of filing securities as collateral in the Movable Assets Registry, which I know you're going to take us through, and also opportunities for banks and other business organizations through that registry, and benefits of that registry. What are the benefits of the registry? And so I think now we will move to our next presenter. Our next presenter now is Dr. Jeramba. Dr. Jeramba is my senior. He's a seasoned lawyer with over 20 years post-admission experience. Dr. Jeramba, we are following you. Looking forward to getting there. He's a managing partner at the law firm of Wanyaga and Jeramba Advocates, where he specializes in commercial and financial law with extensive transaction, dispute resolution, legislative drafting, training, and regulatory compliance experience. Daktari, one of our staff here actually said you are his lecturer at the university. Dr. Jeramba holds an array of academic qualifications, including a doctorate of philosophy degree in law of the University of Nairobi. He's also a certified secretary, a CS. He's the chairman of the National Civil Aviation Administrative Review Tribunal. He's also a senior lecturer in law at the University of Nairobi. He has also taught at other institutions like Quare Catholic University and the Kenya School of Monetary Studies. He chairs the Postgraduate Studies Committee at the School of Law, University of Nairobi. He's also an author. I think he'll tell us more about that, of the Law of Financial Institutions in Kenya, a book that is published by Law Africa, which is the key text used in teaching banking law in all major universities in Kenya. He has also authored articles in many areas of law, including company, sports, financial services, intellectual property, capital markets, electronic commerce, ICT, and other areas, even environmental law and things like that. He has previously served as a board member of the Council for Legal Education. He's also a member of the International Association of Sports Law. Dr. Jeramba was also very instrumental in the enactment of the Movable Property Securities Act 2017, which is what he's going to unpack for us today, as well as the regulations to that act. So Dr. Jeramba, we are glad to have you. Karibu sana. Please take it away.
Thank you, Sharon. And good morning, everyone. Happy to be here today so that we share a bit of what we have on the Movable Property Security Rights Act and how it applies to intellectual property, and more so to copyright. Now, even as I begin, I think I'm here to achieve at least two things, which once I achieve them, I will say that that's what I came to do. Number one, of course, is to bring awareness that it is possible to use intellectual property as collateral in Kenya today. And number two, to tell you how to do so. And those are the two main reasons that we are here today. Now, of course, we have had a long relationship with the Business Registration Service spanning over 5 years now on the Movable Property Security Rights regime, from the pre-enactment stages through the enactment of the Act to date. And therefore, when I'm here, I'm more or less actually part of BRS, and we are happy to be here. Now, I want to start with, of course, the basics, which I can say we all know about what intellectual property is. Of course, here what I'm trying to do is, just in case there is someone who would need a definition, that's what I'm trying to do on this slide. And I'd just say that IP is basically that asset that one acquires or creates by way of the use of his intellect, the use of the brain. And therefore, you get that because you can be able to innovate, an invention and all that. And the list that is there is wrong. That is, of course, copyright among the many others that we have listed there. And therefore, when I talk about intellectual property, I'm talking about all these and saying that they can be used as security for purposes of acquiring a loan. Now, of course, where we are coming from a situation whereby we couldn't do this. And therefore, that's why it is important for us to actually get into this, to know that it is possible that one can use IP as security. Now, of course, what in this side what we are trying to do is basically to go on to define what we mean by the other terms. So that is a copyright, patents, trademark. That is where I'm talking about the things we already know, so that we can now be able to move together after having confirmed that we all know all things. So we are coming from a situation whereby, or a position whereby land was mainly what was used for purposes of getting loans, getting financing, and therefore it had to, of course, take some time for us to think about a situation whereby anything else other than RAD can be used as security. Of course, traditionally, we used to have others that could be used, which were still movable through the Hire Purchase Act, for example, and the Chattels Transfer Act. And you'll see as we move on what has changed, and you'll see why those were not the best ways through which we could use movable assets as collateral. As you realize, it wasn't possible to use the Chattels Transfer Act or to use the Hire Purchase Act to take security over intellectual property. But as I'll demonstrate, now it is possible to actually use intellectual property now for purposes of getting a loan. Now, so the secured transactions regime, this is what I'm talking about. By the movable property security rights, we also refer to it as secured transaction regimes, because it is that legal framework that gives us the capacity to secure transactions for money or to secure financing. And therefore, we say that we have secure transactions where there is a transaction that creates a security interest. Now, of course, this distinguishes a financing arrangement that is secured from that which is unsecured. That is, if we are talking about a loan that one has been given without giving a collateral, then that is unsecured. But then where we create a security interest of a certain asset, then that becomes a secured transaction. And the Movable Property Security Rights Act operates in that sphere, whereby we are giving collateral, we are giving a security for purposes of getting financing. Now, a security interest arises where there is one person who is borrowing and there is another person who is lending. And therefore, that's where we talk about the creditor-debtor relationship. That is where we would say that they will create an arrangement of lending from one to the other person or advancing a credit facility. Now, however, it becomes a secure transaction, as I've said, where there is a certain collateral that is being used. Now, this then leads us to the position whereby we may have a creditor and a debtor, and we have another person we call a guarantor. That is where we would say that because a secured transaction must have a certain collateral, then there must be the collateral. And therefore, if the debtor or the borrower does not have an asset, then he can get someone else to give an asset to be used as collateral. And that person who is the owner of the asset is the person we call the guarantor. Indeed, for purposes of the Movable Property Security Rights Act, the guarantor is the important person, not necessarily the borrower. In some instances, you find that the borrower and the guarantor are one and the same person. That is, if the borrower owns the security, then we can say that that person is both the borrower and the guarantor. But if the borrower does not own the security and gets someone else to give him an asset to use as security, then that other person is a guarantor. And therefore, for our purposes, a security agreement exists between a guarantor and a creditor. So whether or not the guarantor is the debtor in this particular case. And therefore, the guarantor and the creditor are the ones who enter into the security agreement. Now, a collateral is used as an assurance that in the event that the borrower defaults, then there is something that the lender can use to realize. That is, there is a way that the lender can be able to recover his outlay if there is default. And therefore, we say that a security or an asset that has been given as collateral is not necessarily really being taken completely by the lender. We are just saying that this is just in case there is no payment or in case there is default, so that now the lender can be able to get something to sell and recoup the amount owed. Now, the movable collateral regime in Kenya, Shigadi has mentioned where we came from. And the main statutes, of course, included the Chattels Transfer Act, which was repealed by the Movable Property Security Rights Act. Of course, the Companies Act applies for purposes of debentures and so on. The Hire Purchase Act again applies, and this again was amended by the Movable Property Security Rights Act. So the Hire Purchase Act still exists, of course, with amendments brought about by the Movable Property Security Rights Act. Now, the Hire Purchase Act, of course, had a regime whereby one would use an asset as security. But then you realize from the Hire Purchase Act that what it gives is basically just what we may call an acquisition security right, because it only gives you that right where the lender is the one actually selling the particular asset, and not in the other situations whereby you already have an asset and then you are using it as security. And so there were, of course, many other laws that were relevant, and of course, some are still relevant to date, which would have a role or even had a role even before to play for purposes of secured transactions. Of course, the law of contract act still applies because it is the main law in respect of contracts or for purposes of agreements. Stamp Duty Act applies due to the question of payment of stamp duty, and as perhaps you mentioned later, you realize that the Movable Property Security Rights Act exempts transactions registered under the Act from stamp duty, and therefore, of course, to make it more accessible and so on. So these are the acts that are used to operate together with the others for purposes of secured transaction. Now, this regime or the previous regime was faced with challenges, and some of the challenges included what we have here, that is multiplicity of laws. That is to say, we used, for example, to have the Hire Purchase Act, the Chattels Transfer Act, all those which would give regimes, different regimes on how one could have a secure transaction. And therefore, that, of course, brought a problem even to the lenders, because the issue is which law do we use, and therefore which law would we use for purposes of recovery in the event of default. Again, there was a question of limited scope of movable property securities, and of course, the main illustration we can use today is that none of those laws recognized the use of IP as collateral. Again, there are weak enforcement mechanisms. You see, weak enforcement mechanisms because the law wasn't really clear on once you have created a security by way of, for example, the Chattels Transfer Act, then do you have a good enforcement mechanism under that act? Again, the question of we can dispatch registry system. We had a Chattels registry, we had a hire purchase registry, we have the company's registry for purposes of debentures, etc., etc. And therefore, you would have a problem with even the enforcement, because the registries were different, and therefore if an asset has been used and registered in different registries, therefore there is a question of which registry takes precedence. The question again of compromise and unclear priority rights. Now, where there are different legal regimes in respect of collateral, then you find that we can't be very sure which one takes which registration will take priority. And therefore, we needed one law, we needed one regime that would clear this question of priority, so that we can be able to know in the event that one asset has been used as collateral through or to several lenders, then in the event that there is default, who has priority over who. Of course, emergent forms of personal property were not covered. Delays and updated provisions. So, of course, when we talk about delays, we are talking about the delay in the registration process. See, when we used to register shuttles under the old regime, one, of course, would require to prepare, of course, those lengthy documents. You would require to, of course, take them to the RAD's office for stamp duty. Of course, that takes a week, 2 weeks, 3 weeks. Then you'd, of course, now go back to Sharia House and then register them in the registry. Of course, the total period you take would be, we may say, a minimum of 1 month for you to say that you have registered one chattel's mortgage. The same would apply to hire purchase agreements. But now we are talking about, and as you shall see, we are talking about a registry system that will give you instant registration. That is to say that you can agree once you have a security agreement between the parties. Then within a minute you can be able to register, because you do it from wherever you are remotely, as long as you have access to the internet. And therefore, if that is not innovation, then I don't know what is. Because what would have taken time, what would have of 1 month or more, what would have taken a lot of effort and all that, takes the shortest time possible. And of course, the least effort, or least disturbance to other activities. Now, therefore, the old regime limited the utilization of movable collateral for purposes of accessing credit. And therefore, there was this need to come up with a system that would make it possible to access credit, and we may say make it easy to do business. That's why we keep talking about ease of business, of doing business. When you're talking about this, and among other many other things, because it is just the end result here is we need to access credit for purposes of business. So how do we do it? And therefore, we needed a law that would enhance that, so that we can make it as easy as possible to access credit. And that is how come we got the Movable Property Securities Act of 2017 to deal with these problems and to address those challenges. Now, of course, we also needed the act with a view to changing the way we do business. With the changing times, we need to do things in a digital manner. We need lending using almost everything that is any thinkable asset as collateral. That's why we needed to have this particular sort of regime. And this is what now came to be, so that we can move from the traditional use of number one, the immovable assets that we used to have, that is RAD and so on. Of course, we still use them, but then we want to ensure that because not everybody has RAD, almost everybody has a movable asset. If that is so, then that means that actually everybody can get or can access credit if some collateral is required, because everybody has a collateral that can be used. Now, the scope of this act is the widest possible. Now, we say that the Movable Property Security Rights Act applies to security rights in movable assets, all thinkable movable assets. That is, anything that is not land or buildings is capable of creating a security right. and therefore it is possible to use it in respect of anything that you can think of. That is, it doesn't have to list in the items one can use. Therefore, that's why we say that it applies to every transaction that secures payment or performance of an obligation. So now anything that is included there is part of what we can use as a collateral. And what we have given here are just examples. And these examples, we are using them with a view to showing you the extent, so that these are not the only ones we can use. But this is just to tell you that all these are what we can use as collateral. And this tells you that it goes beyond what we had traditionally, so that now all these can be used as security, including account receivables and so on. So meaning therefore that you can think of anything, and then that item, as long as it is a movable asset, then that asset becomes a collateral that can be used. Now, of course, there are certain exemptions, and these exceptions include, of course, book entry securities under the Central Depositories Act. So we are talking about securities that can be traded on the capital markets exchange. We are talking about exemptions relating to RAD. Anything related to RAD is not involved here. We are talking about security rights of vessels that are governed by the Merchant Shipping Act. You cannot create a mortgage under that and register it under this act. We are talking about security rights of aircraft because there is a law that provides for it. That is the Civil Aviation Act. We are talking about a lien, charge, or other interest created by some law. That is, if there is some law that is expressed that in respect of a certain asset or a certain kind of lien, this is a law applicable, then that is not provided, will not be covered by the MPSR. And of course, security rights in proceeds of collateral if they constitute an asset governed by another law. So that now, if there is a law that provides expressly that this is not subject to MPSR, then that is not, it is exempted from this. Now, by movable assets, we mean we are talking about the types of collateral that may be offered as security, and we are talking about tangible and intangible assets. Of course, for our purposes today, we are talking about the intangible assets. But just to mention about the tangible assets, we are talking about assets that one can think of. That is from motor vehicles to household goods to crops in the field. The crops in the field are also tangible assets. You can use that as security, and so on. Now, to intangible assets, mainly we talk of intellectual property, which can be used as security. Now, the question is, how do we create a security right? How do we create a security right? Now, when we are creating a security right, we say this. We say that you create a security right because you are creating a security right under this act, so that you can be able to then have a way of enforcement. And therefore, without creation of a security right, you cannot be able to enforce what we have, what you want to create as a right. Now, how do we create a security right? Now, a security right is created through a security agreement. So you create a security right through a security agreement. Now, remember that we said that the two parties, or the two main parties we have are the lender, that is the secured creditor, and the grantor. The grantor, remember I said that the grantor may be either the debtor or the other person who has provided the security or the collateral that is to be used. And therefore, the security agreement will be between the two. Now, what this act does is that it does not prescribe a format for security agreements, meaning therefore that parties can be able to come up with whatever sort of agreement that they may want to have. Now that means that it is for them to decide what agreement captures whatever the rights and obligations they want captured. And that means therefore that it is upon the parties to have an agreement that they want to have. Now that of course means that the lender or the secured creditor should be able to look at the argument and see that this one secures his interests. The same thing applies to the data. He must be sure that it captures his interests and therefore they are protected. So these agreements, why the Act does not provide for a format for the same, is that these agreements are not required for purposes of registration. So they are agreements that are applicable between the parties themselves. And therefore, there is no requirement for their registration. So they remain between the parties. As you see, we only register notices under this regime. And therefore, we do not register agreements under this regime. So all that the law requires is that the parties must have an agreement that is in writing, that is executed between the parties, and which is enforceable under the law of contracts. And therefore, what that means is that, again, have an agreement between yourselves, which must be in writing. And then after that, then you take the other process of registration of notices under the Act. Now, after parties have entered into an agreement, then the next thing that they should do is to contact. Now, we say that a search is important because you need to know whether the particular asset you are taking as security, especially when you are the lender, has been used or utilized as security before. Now, as such, you do on the system, and this will be demonstrated to you. But you go on the system and you seek a search online, and then you get a search, and then you get the results, and then you'll be able to know whether the same has been used. So that means that you'll be able to know before you even enter into a security agreement whether there is this asset has been used as collateral. Now, why it is important to do a search is because if someone else has registered before you, then that means that that other person has security, has priority in respect of this security. And therefore, it is very important to conduct this search. Of course, as I've said, it is through the online registry, so that you can know whether you have priority or not. After conducting a search, you need to then register the notice. Now, we say that the MPSR registry is a notice-only registry. That is to say that the only thing required to be registered on the system is a notice. And we say that this notice is what you use to perfect your security. That is to say, if, for example, you only do a security agreement and you do not register a notice, then the agreement is valid, yes, between the two parties, but then it cannot be used against the third party. That is, you cannot claim, for example, to have a priority over any other person. So that even if you have a security agreement and you do not register a notice, another person can come even 1 month later and register a notice and have priority over you. So perfection of security for purposes of this regime is through the registration of a notice in the registry, and therefore you get your priority register. Now, there are 3 types of notices. Now, the first and the main kind of notice we have is what we call the initial notice. Now, if we draw a parallel with the land or with the movable assets, then you'd say that the initial notice is the charge that one would create, for example, for land. And therefore, you would be able to create a charge over the security if you have registered an initial notice. So this is equivalent of creation of a charge. We say that an initial notice is registered by the secured creditor once they have a security agreement. And for the secured creditor to register this notice, he must have authorization of the grantor. The grantor should authorize that you register the notice. And we say that this authorization may come in either of 2 ways. It may be written somewhere that I hereby give you authority to do this, and therefore you can say you have authorization if you are the secured creditor. Or, and this is a recommended way, or it can be included as a clause in the security agreement. That is, the parties can have a clause in the security agreement to say that the execution of this agreement gives the secured creditor the authority to register the notice on the system. Now, the second notice is the amendment notice. Now, the amendment notice is registered to amend the initial notice. And therefore, this comes in after there is something that needs to be amended on the initial notice that is already on the system. Now, and you can do this by either to add or delete part of the collateral, to effect changes to the guarantor's identifier. We are not about, let's say, the ID number and so on, to remove some information that is unauthorized on the system on the initial notice, to include proceeds of a collateral. We talk of proceeds of a collateral, whereby if you use certain assets and then the guarantor sells the collateral, we say the security right goes into the proceeds. But then we say that you have only 10 days to use those proceeds to recover or to enforce if there is default. But beyond 10 days, you need to amend the notice for you to say that now the proceeds of the sale are the collateral you need. So you need that amendment notice for that purpose. Again, when a security right is being transferred, again, there is need of an amendment notice. We say that a security right is transferred if one secured creditor wants to transfer that right to another secured creditor, then that requires an amendment to the initial notice. Or to add transferees as a new guarantor, that is if, for example, the asset has been sold with the concurrence that the right is transferred, the security right is transferred, then the amendment notice will be done to add the transferee as the guarantor. Third, we have the cancellation notice, and the cancellation notice is registered where either there was no authority to do the initial notice or to register the initial notice, or where there was authorization that has been withdrawn, or the security right has been extinguished. That is to say, for example, there is the termination of the security right because the debt has been paid. So the cancellation notice, again, we can say that this is the discharge of the debt, and therefore once there is discharge of the debt, then this is what is filed on the system. Now, a copy of the notice once filed has to be sent to the guarantor by the secured creditor within 10 working days, and of course this can be done by way of email, or can be done by way of post, or can be done by any other way that the creditor can prove that he indeed gave out the copy of the secured of the notice to the guarantor. Then the question of third-party rights. Remember, we have said that perfection of security right is through the initial notice, and therefore there must be a registered notice if one has if the security interest is to be effective against third parties. And we remember again, we have said that for purposes of a secured creditor transfer having rights over the proceeds, then he has to either get the proceeds within the 10 working days or register an amendment notice. Again, a security right of a movable property may be transferred by one creditor to another. So we have said that too. Now, the question of priority, of course, which is quite important. Here we say that where there are competing security rights created by the same guarantor over the same collateral, we say that these are determined, the priority is determined according to the time of registration of the initial notice. Now remember, we are saying that the registry we are talking about is a registry that registers something or registers a notice to the second. That is, there is a timestamp. And therefore, it is very important to register as soon as possible when one gets a security right of a certain asset. And the time of registration by the second is the one that gives a priority. And therefore, and that is also why we are saying that there is need to conduct a search before a registration or before taking a security of an asset, because there may be someone else who has registered an hour ago over the same asset. And therefore, registration is the most important thing as far as this registry is concerned. Now, because we are saying that even if someone knew that there was a security right, that there was a security right in favor of someone else due to a security agreement, that does not affect the priority of a creditor who has already registered an initial notice, because an initial notice is what gives priority. Now, we have said also security right is terminated, of course, as per the terms of the agreement. But again, also, there must be the registration of a cancellation notice, so that now, once there is a termination of the same as per the agreement, then the next thing that should be done is a secured creditor registering a cancellation notice. And therefore, I remember what again we said, that the security agreement is what captures the duties and the obligations and the rights of parties. And therefore, all that is contained in the security agreement, so that where there is a dispute about what has been registered on the registry, we go back to the agreement to see what terms the parties had agreed to. It's a security agreement. Now, how do you realize a security right? You realize a security right through the means that have been provided for under the Act. That is upon, we say either a creditor can exercise rights under the security agreement without applying to court. And here we are talking about using the Act without going to court, by way, for example, of appointing a receiver where the movable asset, for example, was a floating charge, or the release of the movable asset, or taking possession of the movable asset, or sale of the movable asset. Of course, as we will say later, here comes in some little bit of a challenge when you are dealing with intellectual property for purposes of exercising these rights. But then, of course, this is where the agreement comes in as to what the parties had agreed on. Because, for example, parties have to agree that if the security right is copyright, then the agreement for purposes of covering, let's say, the secured creditor should also include, for example, that the royalties that come are also captured or are also covered as part of this, so that when we say that one of the means is to take possession of the movable asset, then you'd be saying that the secured creditor is taking possession of the asset plus the royalties that come from that particular asset. And therefore, it is really important for when especially dealing with IP to have everything captured in the agreement, so that it is clear that it is not just the copyright itself that one can take and sell, but it is the copyright plus the royalties that come through or by virtue of that copyright. Of course, there is also the other way of suing the grantor for any payment due at the agreement. Now, the applicable law, you say that for IP rights, of course, because of their territorial nature, we say that the law applicable is the law of the country in which the IP is protected. That is, if, for example, the IP is protected under Kenyan law, then the law applicable for purposes of that IP is Kenyan registration. And therefore, that is where we would say that once you register under the MPSR as security right of an IP, then we can say that you are covered under Kenyan law for purposes of the recovery of that particular IP in the case of default, and also, of course, for purposes of how what rights you have in respect of that IP. And therefore, the creation and the effectiveness and the priority in respect of the security right is basically covered by the law of Kenya if it is in Kenya. Of course, that doesn't mean that you cannot create IP, security rights of IP in another jurisdiction. You can still be able to do that, but this would bring in the question of having the law, the agreement, indicating which is the applicable law for purposes of enforcement. Now, and therefore, IP rights are protected under Kenyan law, governed by Kenyan law, and the MPSR Act applies for purposes of enforcement. Now, of course, the question of securitization of IP rights comes, And of course, there is some difference, of course, between IP rights and being used as security and other assets. And this is because, of course, they are intangible in nature, and also they are special in nature. Because we say that we are about the intellectual invention that has been brought about by someone applying his intelligence. And also there is the difference that comes in due to their territorial nature of their protection. And of course, remembering that the benefit through, I mean, how one gets benefits in IP is through payment of royalties. And therefore, it is not really about sale of a certain IP that gives money as such. It is the royalties that one derives. And of course, there isn't really the possibility of saying that you have possession of an IP right. You cannot really take it physically because of its intangible nature. And therefore, again, there is also the issue of the exclusive rights that one can enforce against everyone else once you have the IP rights of a certain things or certain items. So the Act, the MPSR Act, recognizes IP as one of the movable assets. And we say that that is progress because previously there was no law that had mentioned IP as used as an asset or as collateral. And therefore, this is what now gives us the express legal framework under which we can be able to use IP as security. And the law applicable, as we have said, is the law of the country that we are in. And of course, as you realize, the IP laws in Kenya do not make provision for recording of security rights in IP in the various registry, so that now, whether you're talking about copyrights, whether you are talking about trademark, you are talking about patent, etc., you do not really see that the registry have any mechanism of registering security rights of IP. And therefore, it follows that all security interests in IP then are registered in the MPSR registry for purposes of securing the rights. So it is under this registry that everything about security rights in IP is registered. Now, when a security right of an IP is registered in the MPSR registry, we are not about the borrower still retaining ownership, but then the secured creditor has security right to that he can enforce. And therefore, a notice in the registry or put in the registry is the one that creates the security right. Now, arguably, one can say that copyright is the easier one to use for purposes of collateral. Easier as compared to other IPs. That is easier compared to trademarks, patents, and so on. And we are saying this because we say that, of course, for copyright, we say that there is automatic accrual of rights in a copyright, so that whether or not you have registered the copyright, you have the right over the particular copyright or the particular music, the particular IP that you have created in respect of this. And therefore, it isn't really an issue of saying that you can, because I did register it somewhere, that I do not have copyright over it. And therefore, we can say that it is easier to deal with than the other IPs for the reason that in other IPs, we still need to have one do the searches in the two registries to be able to say that this person is the owner, and number two, this person has registered a security interest for it. Now, of course, again, arguably one can say that the market for copyright is easier because it's more established. Because, if, for example, it's music, you can basically be able to see it happening. If it is books that you can see in the market, it's possible to say that you can be able to control that and so on. So a disposal may be a bit, of course, easier. Not that it is easy, of course, but it is easier as compared to the others. Now, this brings to the fore the question of valuing of IP. And the value of an IP is of an IP asset comes from the right of the owner. That and we say that we may need to know what is the value of an asset, number one, even for the purposes of advancing credit for that asset. But number two, at the point also of realizing the security. And of course, by valuing, we are saying we need to know the quantifiable value, how much is it worth, and how much can it give the creditor in the event he wants to realize it. And we are not about, of course, the economic benefits. We are not about whether it enhances value of other assets, so that we can be able to estimate the value of IP. And therefore, there may be need for valuation of IP assets, so that we can be able to do the securitization and also to realize. Now, however, that need not be a serious problem for our purposes. Why do I say so? There is no requirement under the MPSR that assets must first be valued to be used as collateral. And therefore, it is basically for purposes of the due diligence of the creditor to value an IP asset. So it isn't a requirement that we must value it. So no asset is, so that the value, the amount that is indicated on the initial notice is basically the amount that both parties have agreed on, and this is the value of the asset. So there is no requirement for valuation. And therefore, of course, valuation is important for purposes of knowing how much even your asset is worth. But then it doesn't mean that you have to do it before you get to register an initial notice. So it is between the parties to decide whether they want to do a valuation or not. Of course, as we are saying, the value of an asset basically represents the future economic benefits, and therefore it is important so that we can know the monetary value of assets. So it is important, of course, for many other reasons, not just for purposes of securitization. But even when we talk about valuation or management of IP assets, you need to value it. When we are doing audit, we need to know what values we ascribe to various assets that we own. We need, even when we are settling disputes, when we want to attract partners to our enterprises, we need to know the value of our enterprises. When we are licensing, in mergers, acquisitions, etc. So valuing of intellectual property is very important. Of course, in this jurisdiction, it is not one of the things that is done a lot. And there is also the challenge of the confidential nature of valuation of IP assets. And therefore, rarely will you find somewhere that we have a certain place. You can go and get a value of a certain copyright or value of certain IP assets. But we need increasingly to develop this so that we can be able to say that even, for example, when a company is giving out its annual audited accounts, then you can be able to say that actually they have factored in the assets that they have, which are IP assets, copyrights, they have trademarks, etc. It should be important to do that for purposes of knowing the full value, full worth of our enterprises. Benefits of IP securitization, of course, provides an additional basis for obtaining credit. Of course, because IP for long has been an untapped source of collateral. Of course, once you securitize that and get money, of course, you get a quick return on for purposes of research and development, and to recoup what you have already spent. It also brings additional value now to your business, and therefore, of course, also it offers an alternative investment to investors, so that now people can know where to invest. Of course, it tells us what we already have, so that we can be able to know the worth, and therefore we can know how to develop it or to grow it more. By that meaning, again, it promotes innovation, because once we know that once you have something, then you can be able to use it to finance further research. That means that that promotes innovation. Overall, it fosters growth of startups or growth of artistic talent, because if you can access credit by way of by using your art, then that means you can be able, of course, to feel motivated and all that. Again, also, if we continue this, it may lead to uptake and commercialization of IP rights, and therefore move us from the dominance of immovable assets, security, what we have been doing over a long period of time, and move to immovable assets that include IP. Now, of course, there are challenges that we can identify in the use of IP as security. And of course, one of them is the lack of a standard form of valuation of IP assets. And therefore, this, of course, brings hindrances to the commercialization. Again, also the lack of a link or connection between the various IP registries and the MPSR registry, so that one can be able to see, if you do a search in one, then you can be able to see whether there is an initial notice registered in respect of the particular asset. And of course, what then that means that financial institution feels that rating against IP is relatively risky, because you do not have a connection between the registry. Now, of course, that has brought brings about the issue of whether they really want to rate, and what some would require, or some financial institutions would require, is that actually one transfers the IP rather than create a security right. Of course, this is cumbersome, because it means that you transfer your security right, your IP rights to the reader with a clause for a transfer when you fully pay, which of course doesn't safeguard the rights of the owner. And therefore, that's why we promote the use of MPSR for purposes of registration of security rights, so that once you pay, it's all about discharge through the use of cancellation notice. Now, of course, once, of course, it is there, or once the initial notice is registered, then there is also the need to remind the proprietor to keep on renewing the IP rights. So the creditor would have to ensure that the rights have been renewed, so that, of course, they do not lapse and then lose the security. The territorial nature of IP rights, of course, the issue of enforcement outside the jurisdiction comes in. Again, there is a question of whether there is a market. There is no, and we say there is no established liquid market for IP rights, and therefore this brings the enforcement hurdle for traders. That is where, for example, do you put up for sale copyright that you have of an asset that as a later you had taken as security. And this is something perhaps as a country we need to think about, and even as Kekobo, I think Kekobo should think about this, which of course we can have a discussion about actually the creation of an exchange for copyright, so that we can say that we have a market, a ready market where copyright is sold, where copyright can be put up for sale, and then of course similar exchanges for purposes of sale of trademarks, sale of patents, and so on. Because if we had an exchange, a market for that, then you'd say that it would be very easy to enforce, and that would now generate excitement. That would make traders feel that in the event that they use IP rights as security, then in the event of default, there is a ready market. There is a market where they go for purposes of that, and therefore that's why I'm saying we may need perhaps to discuss with Kekobo to see how we can move to that next level. There is also the challenge of infringement risk, whereby, of course, due to the unpredictability of IP, you may find that actually there are people who are counterfeiting etc. And therefore, that brings a challenge. Of course, general lack of awareness on IP rights, both in Kenya and even elsewhere. And if there is a lack of awareness on IP rights, then of course, even there is lack of awareness on MPSR in respect of IP rights. And therefore, because of that, then people do not know the commercial value of the IP they hold. And therefore, they may not be able to think of using it as security to obtain financing. And then, of course, that also one of the illustrations that tells us that is so is the sheer number or percentage of IP rights in Kenya that are owned by foreign entities. And therefore, we still have not had enough awareness on IP rights in Kenya. And therefore, even the lack of the awareness and the lack of the market, the lack of the standard valuation for IP makes traders reluctant. Now, of course, we may say one of the challenges also is the lack of awareness of the MPSR regime. Of course, this we are surmounting this because for the last 1 year or so, or more. We have been doing quite a lot of public awareness on the MPSR regime, and therefore increasingly we are getting more uptake on the same. Now, a lack of a standard way of description of movable assets in the initial notice, and remember we say that in the initial notice, you give a description of your assets, such that if it is a copyright, you describe and say that it is a copyright over this or the other, plus the royalties that would come out of it and all that. So there is need for that description. And then another challenge we have seen is that there are many people who register initial notices without conducting a search. And therefore, you may find that now they will come later to find that indeed there was someone else with a priority. And therefore, again, as I said, there is need to do the searches. Now, in conclusion, this is what we are saying. By use of MPSR, we are saying that IP can be used as collateral. And therefore, this makes it possible for owners of collateral, for owners of IP such as copyright, to use it as collateral and obtain financing. And again, we have said that the kind of registry we have, the MPSR registry, is one that is instant. That is, you just go to the internet, go to eCitizen, and therefore it has remote access. You therefore just need a short period of time to go to the system, and then you register your IP as security. So that now you can be able to use it to get money when you are the secured creditor registers it as a collateral. And therefore, you can be able to see what has been registered. So the mere fact that we have this instant remote access system of registry, then that to me gives us a very good way of using IP as collateral. Now, of course, we are also seeing uptake of IP as collateral. As you have seen, we have over 1,000 registered. And it would be important when registration is being done in respect of IP to have a proper description, as we have said, so that we can know as to what is the extent. Does it extend to royalties and so on? Again, also, we have seen that BRS, the Business Registration Service, aims to foster growth in the movable collateral regime. And therefore, that's why, of course, we have these engagements, so that in the event there are challenges, of course, we address them, so that now every movable asset is usable as collateral without challenges. Of course, we need to do more of sensitization of both owners of IP, and we congratulate Kekobo for this initiative, so that they can know what they hold. It can be used as security. And those, of course, the potential lenders, so that they can be able to know that there is commercial value in IP rights. And we have, of course, done a lot of this. We have had several seminars and webinars and workshops with banks and other financial institutions, trying to sensitize them on the use of IP and other assets as collateral, and that's how come we are seeing the uptake that is there. Again, also, we need to foster the establishment of standard valuation methods and have a liquid market. We need an exchange for IP rights. There is also need to see how we can create links between the various IP registries and the MPSR registries, so that we can facilitate a one-stop search, so that once you do a search on one, then there is possibility that you can actually be able to see whether a certain asset has been used as a security. And I will stop there, and I hope I have achieved my intention. The intention I said at the beginning, that is of number one, making you aware that you can use IP or that you hold as collateral, and number two, how you can do it. And remember that we have said that the registry we have is a non-line registry system that you can be able to use for purposes of registration from anywhere that you may be. And you do not need to upload documents on the registry. And therefore, all you need is to get to the registry and input the details that are required in the initial notice. Of course, in case of challenges, we are always available to give further assistance, further information, and therefore ours with BRS is a long-term relationship, whereby we always come in to assist where need be. So thank you very much, and back to you, Sharon.
Wow. Oh, wow. Thank you. Thank you. I think these webinars are not doing us justice, because then you can't hear us clapping for you. But we are really grateful, Daktari. That was so awesome. I have learned a lot myself. I've really learned a lot. I think one of the messages we have struggled to get out is that it's possible to use IP as collateral. That message is home for us in the IP world. I agree with you that there's need to sensitize both the rights holders, the owners of the IP, and also the lenders, to be able to know that there's some commercial value. Because I know in developed nations, IP is almost automatic. They know IP can be used as collateral. But here, someone asks you, uko na gari, no, sina logbook, niko na copyright registration certificate, and they're like, hapana. So I am really grateful. I also agree with you, there is need to have a link between these registers, because as you say, with the MPRS, it's a registry, it's online, and Kekobo also, we also have a new system that is online. So even for copyright registration now, we are able to just go online, key in your details, do your registration, receive your certificate, print it from wherever you are. So I think that collaboration is greatly needed, and so we have take-homes on what to do after this. We shall be continuing this relationship with Shigadi to become more close. So Shigadi, maybe you can take a few minutes to just finish off, and then I can see we already have participants raising their hands. I think we let Shigadi finish up, and then we take the questions once and for all. Shigadi, will you need like 10 minutes or so? Will that be enough?
Yes, yes, I'll be quite quick because, like Dr. Jeramba has indicated, this register, it's the secured creditor who registers this. So I'll try and be quick as possible, just so that everyone can have a feel of how the registry, how you go about making an application in the secured transaction registry. I will log in using a test server.
So Shigadi, before I get off, Kaindo, Otieno, Marvin, I see you. We will take the questions just after this presentation. Thank you.
Thank you, Sharon. So the first thing you do is to log into the eCitizen platform. You log in, key in your credentials, and then you log in. Once you're logged in, then you can see that it indicates it's Shigadi Mwakio on this side. But if you're making an application on behalf of a company, that company needs to give you access. And what happens is you should never lodge the initial notices on when the icon reads your name. What you need to do is I'll use the LO business here. So what I need to do if I'm making an application on behalf of a company, I need to click view, and then the icon has changed. So it means that I am making the application inside the company's account, which is the right way to go about. If it's the bank, then you're making the application on behalf of the bank, and the bank will appear as a secured creditor. So the first thing that Dr. Jeramba has indicated is that you need to conduct a search. This is very, very important. I cannot overemphasize why. I think it is so clear from what Dr. Jeramba has indicated that you need to ensure that you conduct a search so that you do not lose on the priority should you choose to issue the loan. So when conducting a search, you can conduct it using the grantor's identification or the motor vehicle chassis number. So if we use the grantor's identification, it could be either an individual, be it foreign resident, be it a Kenyan, be it a foreigner. It could be a company, a Kenyan corporation company. It could be an unincorporated body, SASRA and the others. And then it could be a foreign company or a foreign unincorporated body. So I'll take Kenyan citizen. So we can use my ID number. So all you need to do is key in their ID number, And then once you have done that, you proceed. And then, of course, the question is there, and then you finish. So what will happen is will be taken to a payment page. And in your case, you're supposed to pay 550. In my case, now I will pay 2 bob. I want to do a practical one, so I'll go ahead and pay. So what we have experienced with the most secured creditors is you do find, the reason why I'm insisting, you need to ensure that you log into the company's account. Once you have lodged that application on your behalf, then unfortunately there is no way from the registrar, the law does not mandate us to make any changes to the information that has been entered into the registry. I'm having a challenge with proceeding. Okay, I don't know what the challenge is, but anyway, so once you have paid, then you should be able to get a such certificate. If I have any from my records. Okay. In the interest of time, I will once, as we go along, I should be able to give you what a such certificate will look like. And then, so the first thing that you need to do if you're making that application is you are required to click the initial notice. Will require, like Dr. Jeramba has indicated, the borrower need not be the grantor. So the owner of the asset will need the information of the owner of the asset. So the grantor could be a Kenyan citizen, a company incorporated in Kenya, and or an incorporated body. So what I need to mention is I had talked about integration. So other than us integrating with IPRS, we have also integrated with the company's registry. And for the companies, we are able to query the information about that particular company in our system. What we don't have is for the other unincorporated bodies, such as SASRA. So what we are currently doing is for SASRA, we request them to write to the registrar so that we can key in that their information from the backend, such that when they are making their application, they need not type that information again. And like I have indicated, it is an institution, and someone should not make an application on their account if the secured creditor is an institution. So once we've created that account, then the information about the secured creditor as an incorporated body is auto-generated. Sharon, confirm you can see my screen? Okay.
Yes, now I can see your screen.
Okay, so I'll key in my ID. And then, like I indicated, all you need is an ID and first name, then we verify. The KRA PIN is not a mandatory field. So we'll key in the postal address, then an email address, and then a telephone number. If you have if you're using more than one grantor, owners of the assets, then you can add as many as you want. Save and continue. So the secured credit, we have two categories of secured creditors. We have the consensual creditor, easy, we have consented, and then we have the non-consensual creditor. This could be the official receiver, it could be the landlord, it could be the judgment creditor, it could be a government agency, including KRA. So in our case, let's take consensual creditor. So you have realized that the information about LO business has been auto-populated. So all you need to do is just proceed, other than before we used to ensure that you key in this information. Save and continue. Dr. Jeramba has talked about describing the copyright. So you could do it as per the agreement. You could copy paste it here or describe the best way that it can be identified. This is just for our statistical purposes, whereby we need to know if you're not the grantor, then just give us the detail of the borrower so that we can know, has this law really met the intention that was there to begin with? So female. Then Dr. Jeramba has also talked about the period of effectiveness, which should not exceed 10 years. So if you key in any information, if you key in the months more than 120 months, then you will not be able to proceed. Just ensure that you indicate less than 110, and then you add the amount that is secured. We have more currencies if you wish. If you've used different currency, all you need to do is click add and indicate the various currencies that you are using. Another important thing, has the grantor authorization been obtained? Dr. Jeramba has indicated that it is important before you proceed to ensure that you have been able to obtain the grantor's authorization. If you have not, you're not able to proceed. Save and continue. So again, we normally request you to confirm the details. The registrar has no way of amending the information that has been keyed in. So kindly, when you're making the application, ensure that you counter check to see that the information that you have keyed in is per the agreement that you have. So I will hereby confirm and finish. So once that is done, you are able to download the initial notice. So that is how your initial notice will look like, with the details of the grantor, the creditors, the collateral, and the secured loan. So Dr. Jeramba has talked about two things, amendment and cancellation. So every application that you make will appear on this interface. So if you intend to make any amendments to the said collateral, all you need to do is click view, then you amend the notice. Are you sure? Yes. So you can make any amendments. The amendments, the initial notice, every application is free save for the search. So save and continue. Let's say we just want to add the amount. The moment you have made the amendments, you do find that the status changed to amend. And so if you conduct a search, you will be able to obtain the amended notice. And if we have come to an end, that you've already paid up your loan, then all you need to do as the secured creditor is click cancel, And then Dr. Jeramba has talked about the various reasons within which you are able to cancel a notice. So the right has been extinguished. So cancellation is successful. So that is all about registering, conducting a search, making an amendment, and doing the cancellation. I've indicated that if you're making the application on behalf of the company, then you need to have been given access. I'll just quickly show you how you give someone access. Once you've logged in, gone into the business account, you click the top right here, access, and then you remove this. I don't have the rights. Okay. So you need to click access, and then you can add a user. So all you need to do when adding a user, you use their ID number, you search the individual, and then we have various access levels. You can give someone an operation access, or you can give someone an admin access. What we normally advise is that be sure who you're giving the admin access, because you can see that the admin is able to make applications, change the particulars, and manage other users. So whoever you're giving the admin rights, we normally recommend that you give operations access, because should anything happen, then at least the person you have given admin rights, you can tie them down to the changes that they have made to that particular application. So from the registry, that is it. Sharon?
Thank you so much for that demonstration. Okay, we don't have much time, so I think we should go straight into the questions. Initially, I had two questions from two people. Kaindo, you had raised your hand. The other person, kindly raise your hand again. I can't remember the name. I can see there's Munyoki Pamela. So let's start with Kaindo's question. Kaindo, you can ask your question. Then we take maybe 3 or 4 questions. Then now we'll go back to the answers. Unmute yourself, yeah?
Thank you, Sharon. Thank you, Dr. and Shigadi. Now, mine is a very quick question. I have 2 questions, probably Dr. I think are directed to Dr. Now, just a clarification. You did indicate that a security has to be registered in the MPSR registry. So does that mean that in addition to the normal registration, like for example, if it is a patent, it is registered at KIPI, copyright probably at Kenya Copyright Board. It means that if you intend to use it as a security, it also needs to be registered at MPSR. And secondly, it is very good. My main interest was on valuation. It is very good that you gave it justice, but I just wanted to find out whether there are experts who deal with valuation of IP, specifically in Kenya. Could you know any? Do they exist? Those are my questions, Sharon.
You're on mute.
Let's have Marvin Otieno. Marvin, are you there?
Yeah, I'm here. Thank you, Sharon, for the opportunity, and also Dr. Jeramba. I have 3 concerns directing to Dr. Njambara. One, I recall you saying that when after cancellation of the notice, the secured creditor has to serve the grantor with the notice within 10 days. So my question is, what is the effect of the secured creditor not serving the grantor with the cancellation of the notice within the time frame of 10 days? Second is there's that right to sue in terms of enforcement of the security right, which the secured creditor has against the grantor. So my question is, with regards to right to sue, which court has the jurisdiction to entertain such suits? And then I didn't clearly get on the third-party rights, so kindly if you could just quickly go over it. So that is all from me. Thank you.
Thank you very much. Let's have Pamela Munyoki. You can lower your hand, Marvin. Munyoki Pamela, take the floor.
Thank you. Thank you so much, Ms. Wata. I am very glad to be in this webinar. I was once a student under Dr. Jeramba, and I'm very, very glad to, be taken back to, his wisdom again, yeah, if I may put it that way. My concern would be on valuation again. I know we have, extensively talked about it, and more so in regards to copyright. My issue would be in terms of branding, trademark, and just looking at the volatility when it comes to matters branding. How are we able, what can be done? I know it is a challenge, but I just want to know what can be done to make sure that, we can properly ascertain value when it comes to branding. Because again, a brand is here today, tomorrow it's not there. I'd like to make reference to Nakumat, for example. Such a blue chip company going down, and it had so much value when it comes to branding. So my concern would be, how would we, value properly matters brand so that we can ensure that, people are able to, take advantage of the MPSR. Thank you.
Thank you. Any other question? Any other person? We take one more before our presenters can answer. I want to just also give a shout out to all our guests who have logged in, and especially our advocates. We see you. Thank you for logging in, for joining us. So ask your questions, have yourself. I see Menes and Partners. I've seen Polycarp Advocate. Karibu Sana. Thank you for logging in. If you have one more question,
if you're still able to, can you access the chat? There are a few that have been raised there.
I cannot access the chat, unfortunately. So maybe Shigadi, if you can access the chat, let's take this one from Wycliffe, from Jacket, and then once you're answering, if you can also access the chat, then you can still pick those ones from the chat. Shigadi, that's okay?
That's fine.
Yeah, I'm sorry. For some reason, my computer is not accessing the chat. Jacket?
Thank you, Sharon. Mine was just maybe on the statistics that Shigadi gave us. Probably she may be particular on copyright uptake. Maybe the number so far, so that at least it can inform some of the actions we may take.
Okay, thank you. I think now I'll give the presenters the floor to respond. Daktari, we start with you or Shigadi?
Let me go first because mine is short. On the statistics, I'll have to get back to you because we have to have it pulled out from the system.
All right, that's fine.
I think Shigadi, for us, we actually, that's an interest we would have, just to be able to gauge the use of copyright in particular as collateral. So we'll get in touch and then you can see if you can pull for us that statistic. Thank you. Daktari, take the floor kindly.
Thank you, and thank you very much for these questions. I think the first question was whether, I think if I got it correctly, whether you have to register your asset on the registry if you intend to take or to use it as collateral. Now, the answer to that is no. Now, you do not, persons who are owners of assets are not required to register their assets on the system. So that an asset remains the same way. If, for example, it's registered in a certain register, or it is even a movable, a physical tangible asset, you don't register them. The registration only comes at the point of the security agreement or creation of a security right. And this is where we are saying it is the secured creditor who registers the initial notice. And therefore, there is no requirement for registration of assets on this system. So there is no requirement. It can't actually be done. There is no mechanism in the registry for registration of assets. All you register are the initial notices, the amendment notices, and the cancellation notice. Now, the other question that the first speaker asked is whether we have experts to value IP, and that was also asked, I think, by Pamela. And I think I can also see it on the chart about valuing of IP. Now, let me put it this way. In this country, IP is valued every other day, especially when there is sale of let's say these IPs, and when of course there are mergers and acquisitions of companies which own IP. So they are valued every other day, and the only thing is that it is usually a confidential way that the public may not know how much value was ascribed to a certain IP, but then they are valued every other day. And then the issue then is, someone asked, do we have any experts to value? And then you say that valuation has various methods. You value IP through various methods. So there are many methods of valuation, and therefore the only thing we say is that we do not have a standard way of valuation, but there are various methods. Now, to give an illustration and an example to ask whether they are experts to value IP in Kenya. About 13 years ago, there is a company or a firm that is called Business and Law Institute. That, of course, was established. I'm saying was established because I was part of it. I'm still part of it, the Business and Law Institute. And one of the things that that firm was doing and was to value IP in Kenya. But because of the confidential nature of IP valuation, and because of the only time IP valuation is required is only when there is a transfer, for example, then you find that there is no business as such for that. Indeed, to say that the actual position is that over those 13 years at the Business and Law Institute, we actually, I think, have valued less than 10 IPs. For 10 clients, there may be several, but for 10, maximum 10 clients in a period of over 13 years. And therefore, to say that it is because owners of IP have never seen a need to value IP, that is why we do not have the development of valuers of IP. Because every time the Business and Law Institute approaches a company to audit and value the IP assets, then the question always with the enterprise is, what value does it add to us? If we know, then what? And therefore, that has been the issue. But then, yes, there are valuers of assets in this country, or of IP assets in this country. The issue is whether the owners of IP assets want them valued, and whether they are really ready, for example, to pay for it. So at least that answers that question. Now, then there is a question, I think these ones were asked by Marvin, after cancellation of notice served within 10 days. Now, yes, every time a notice is put on the system, and we have said it is a secured creditor who registers it, then it is the creditor's duty to give a copy of that notice to the grantor. And we say, for purposes, number one, of ensuring that you have communicated what you agreed, so that even the grantor can see that you have done so. Now, if you do not do that, and they start from the initial notice, if you do not give the copy of the notice to the grantor within 10 days, if later on, for example, the grantor realizes that whatever you put there was without authorization, then now that would give rise to an opportunity for the grantor to use to actually say that this is not effective anymore. And because the law required you to do it, you didn't do it, and then later on you find that there was something that was put that wasn't supposed to be there. And the same would apply to even the amendment. And even when you talk about the cancellation, you need to notify because it has been cancelled, because it is a requirement. So that because if you do not do so, you may find the grantor complaining to the registrar that the notice has not yet been removed, and then of course that would mean that the registrar would have to act because you didn't. So you are supposed to actually notify the grantor with those notices. Now, the other question is on the right to sue in enforcement, which court has jurisdiction? And here we go by the pecuniary jurisdiction of the courts. And therefore, to say that if the subject matter falls within the jurisdiction of a principal magistrate, then you go to the principal magistrate. If the subject matter falls within the jurisdiction of above a chief magistrate, then you go to the High Court, Commercial Division, and all that. And therefore, it is the pecuniary jurisdiction, it's the pecuniary, the value of the subject matter that determines the court you go to, because again, this is basically a commercial transaction. Now, on the issue of third-party effectiveness, what we said is this, that whereas a secured creditor may have an agreement or a security agreement with a grantor, that agreement is an agreement between the parties. And therefore, until the initial notice is registered, there can be no third-party effectiveness. That is, you cannot, for example, come and claim that this asset you are buying, I have security rights over it. And that's why, again, we also talked about priority. That priority comes in respect of due to time of registration. And therefore, if someone else comes to claim that he has a right over this, then you would say, no, I'm the one who came first. And therefore, a third-party effectiveness, as far as MPSR is concerned, comes upon registration, and priority in respect of that comes due to the time of registration. And I think Pamela also asked about valuation. Is the same thing. So I think for valuation of assets, and she said especially about trademark, this is all about, I think, I don't know, but it is more of sensitization and all that. You see, owners of assets, of IP assets, need to appreciate what they own. They need to know what they are worth. You see, we say, if you can't measure it, then you actually, it's like you can't use it. You don't know what you have. And therefore, it is value. It is owners of enterprises and owners of IP rights who are supposed to actually value what they have, so that even in a situation where, for example, you create a charge or a security right over all your assets as an going concern, then you should be able to value your IP right, because you find that whenever enterprises are charging all their assets, because they do not have values of the IP rights, then that one is ignored. Sorry, it's ignored. And that is why we may say that they are undervalued and they do not really get the full worth of what they do. So it is more of the owners to actually go to the next step, ensure that they know the worth of the IP rights that they hold. So I don't. The other questions I think I see on the chat, they are more or less the same on IP valuation. There is one I can see a messy areas on whether valuation is related to the International Accounting Standard 38. We may say so, yes, we can use AS 38, but then you realize that that whereas we may use those standards, they are standards, but they haven't given, it's not really about the method as such. And again, also, they may be important, or the IAS that may be important for auditing purposes. But then the issue here is we need it for purposes of valuation. And therefore, whereas fine, we may apply the International Accounting Standard 38 for that purpose because IP is an intangible asset. But then we need to now, of course, develop what I may call our own solutions using the various methods available for valuation for purposes of valuing, for purposes of securitization. Sharon, I don't think there is any question I haven't answered.
Thank you. You have come through the chat, yeah?
Yes.
Okay. Is there any other question, any other person raising up their hand? And while you do that, probably I could also just show you the registration of copyright on our portal, the nrr.copyright.go.ke. This is how it looks like. So once you come in, if you're a new member, you have to create an account. When you go into creating account, it asks you create individual, corporate. If you want to create as a person, create individual. As a corporate, as a company, you create a corporate account. So for example, I have an account, so I'll go back and sign in. When you sign in, it asks for your phone number. Then I put the password there. So if I sign in, for example, into my account, I have one application I've registered, but you can make a new application. So if I make a new application, it will take me, Shigadi, you can see my screen? Can someone confirm my screen can be seen?
Yes, can be seen.
Yes, Sharon, we
Can
can.
be seen?
Okay.
Yes, it can be seen.
So if you're going to register copyright, it will bring you here to primary copyright owner details. So you have to fill these details. Remember, you have to have a national ID number. If you're a company registration number, phone number, email address, this you must put in here. Then you will, once you pass this stage, then you can be able to continue. But for me, for example, this is one thing I've registered an article, the role of contracts in copyright, and I got my certificate. And you can see my certificate is in here. So I can actually download my certificate and show you how it looks. And so it's also easy like that. Once you go to nrr.copyright.go.ke, then you get a certificate. Once you've gotten your certificate, you can always access it. Remember, you have to log in yourself. It's like an email. So you're the one who really has that ability to log in. When you register, the controls person here cannot log into your account, but they only see, they're only able to see what you have applied, and it goes through the necessary stages until you're granted a certificate. When you're also going to register, you're also going to get different categories. So you have to put your copyright into the category it is. Is it a literary work? Is it a musical work? Is it whatever? Then you have to remember to key that in. So kindly, you can all visit nrr.copyright.go.ke just to be able to help yourself. Any more questions? Anybody else with a question? I actually see we are 4 minutes over our time, but that's okay. We could get 1 more minute if you have another question. If not, I would like to ask Wycliffe Jakej to give a vote of thanks to our presenters and to our participants who have logged in today. You have been patient, you have been good, you have been, I think you're all scholars. You have listened keenly and gleaned from Daktari. Jakej?
Yes, Sharon, I hope you can hear me. I want to take this opportunity to sincerely thank everyone who has enabled this webinar. The presenters, Daktari and Shigadi, personally, I appreciate the knowledge. It is part of the things we have been grappling with out there when we are executing our training mandate, and some of the questions become a bit difficult because probably as we are fixed on copyright, not on business registration, but at least today we have linked our copyright knowledge and business registration, particularly on securitization of copyright and IP rights. We sincerely thank you for your time, your presentation, and we thank all the participants, those who have asked questions. Your questions have been insightful, and we look forward to more engagement from both business registration, BRS, the practitioners, Daktari, and other colleagues who are in the law practice. Those who are content creators who are present, at least today, maybe if there was time, you would be given an opportunity to at least give your views of the webinar. But I'm very certain it is impactful, and this is going to make you use the system more, the MPRS system more, to access credit. And we will collaborate in more webinars. We already have others going on, not necessarily on securitization, but on copyright generally, regarding copyright industry. So with the many and the few remarks, I would like to end there and to say a big thank you to everyone. Thank you, Sharon, for coordinating this. Thank you, Shigadi, for your presentation. Thank you, Daktari. Thank you, everyone. Asanteni sana na karibu Kekobo.
Jacket, I see one hand raised from Mercy Ali.
Yes.
Good afternoon. Just thank you very much on behalf of my colleagues from KSL. I wanted to ask if you can share the recording with us so that we can share the same with the rest of our classmates.
Okay.
Thank you.
No.
Okay. The recording can be shared. I know, Dr. You will also share your presentation. Is that possible?
Yes, I will share my presentation, but I can then ask tell Mesiari that very soon I'm sure I'll be going to KSL to make a presentation on MPSR. So he should also wait for that.
Okay, that's a good one. Thank you, participants. Thank you so much. You can log off at your own. Unfortunately, you can't see each other to begin to network, but you can log off in your own leisure. Have a good day. God bless.
Good day, Sharon. Thank you.
Good day. God bless.
Thank you, Sharon, and the other guests.